It's the start of the 2019-2020 Supreme Court term, so that means that today we're going to be looking at a brief history of the Supreme Court and 4 of its most important cases in American history. My name is Sebastian Giraldo, and you're listening to The Giraldo Show. Good afternoon, everyone. Thank you for tuning in to The Giraldo Show. My name is Sebastian Giraldo, and I will be covering today's episode, and it's going to be all about the Supreme Court. Yesterday, October 7th of 2019, was the beginning of a new Supreme Court term, and it's going to be the first full term with Brett Kavanaugh as a justice in the Supreme Court. And so today's episode is going to focus mainly on the Supreme Court, not on the cases that are going on that have been solved, but I'm going to go into a brief history of what the Supreme Court was and some of its most important cases of the history of the United States. So let's go ahead and start with the brief history. It was established by the United States Constitution in 1789 with the passage of the Judiciary Act of that same year, and had its first assembly in 1790. The Supreme Court is deeply tied to its traditions. Of the federal government's 3 branches, the court bears the closest resemblance to its original form, which is a 225-year legacy. So the Supreme Court was established to basically say the United States law will be comprised of one Supreme Court with all other courts or juries under it. So pretty much the Supreme Court is meant to be a not universal, but nationwide judiciary court where groundbreaking cases could be made if the decision at a lower court was not to the liking of a person. And we'll get into what sort of all that means in a second when I get into in my opinion, 4 of the most important cases of the Supreme Court. So the first Chief Justice of the United States was John Jay, and the first case that was documented was Van Staphorst versus Maryland in 1791, and the first recorded decision was West v. Barnes in 1791. One of the Supreme Court's most controversial decisions was Chisholm versus Georgia, in which it held that the federal judiciary could hear lawsuits against states. So pretty much if one person wanted to sue an entire state for something, the federal judiciary could hear that case, and we get that in plenty of examples. For example, with Brown versus Board of Education was with Topeka, Kansas. So that's one example of a statewide program, I guess you could say. Jay was succeeded as Chief Justice by John Rutledge and then by Oliver Ellsworth, and there were no major cases of the Supreme Court at the time until Marshall came in. John Marshall was the Chief Justice from 1801 to 1835, and he had probably one of the most important, if not the most important cases in the United States history in 1803 with the passing or the deciding of Marbury v. Madison. So basically, in Marbury v. Madison, here's what happened. So, a brief overview of what happened before the case. Thomas Jefferson had defeated John Adams in the previous election cycle in 1800. And so before Jefferson took office on March 4th of 1801, Adams and Congress passed the Judiciary Act of 1801, which created new courts, added new judges, and gave the president more control over appointment of judges. So pretty much what this act was meant to do was for Adams to have more control over judges, to kind of annoy Jefferson at the time, because he was a political opponent of his. So it gave the president at that time, which was still John Adams, more power to control judges and to control courts. So John Adams, he used that act of 1801 to appoint 16 new circuit judges and 42 new justices of the peace. The appointees were approved by the Senate, but they would not be valid until their commissions were delivered by the Secretary of State. So William Marbury, who was the Justice of Peace at the time in the District of Columbia, his commission wasn't delivered yet. So Marbury petitioned the Supreme Court to compel the new Secretary of State, who was James Madison, to deliver the documents. Marbury, joined by 3 other similarly situated appointees, petitioned for a writ of mandamus, compelling the delivery of the commissions. So there were 3 questions that were proposed in this case. Number 1, do the plaintiffs have a right to receive their commissions? Number 2, can they sue for their commissions in the court? And number 3, does the Supreme Court have the authority to order the delivery of the commissions? So here's what happened. The decision of the case, at that time, it was a 4-2 decision, a majority for Marbury. So what the court found was that the refusal of Madison to deliver the commission was illegal, but they did not actually order Madison to hand over the commission of Marbury via writ of mandamus. Instead, the court held that the provision of the Judiciary Act of 1789 enabling Marbury to bring his claim to the Supreme Court was itself unconstitutional, since it purported to extend the court's original jurisdiction beyond that which Article 3, Section 2 established. John Marshall at the time explained that a writ of mandamus was the proper way to seek a remedy, but concluded that the court could not issue it. Marshall reasoned that the Judiciary Act of 1789 conflicted with the Constitution. Congress did not have power to modify the Constitution through regular legislation because the Supremacy Clause places the Constitution before the laws. In so holding, Marshall established the principle of judicial review, aka the power to declare a law unconstitutional. And we've seen this in so many cases, that this case was a precedent for so many cases due to new laws being passed and the Supreme Court eventually deciding that the law was unconstitutional. So this set so much precedent for the entire history of the Supreme Court, and this was a huge decision for Marshall at the time. So there's the first case, extremely important in the history of the Constitution and the history of the United States. Another really, really important case, Plessy v. Ferguson. So in 1892, here is a brief history, a background of what happened leading up to the case. The scene is 1892. Homer Plessy, who was 7/8 Caucasian and 1/8 black, agreed to participate in a test to challenge the act of the Separate Car Act, which required separate railway cars for blacks and whites. So Plessy agreed to participate in a test to challenge the act, so he was solicited by the Committee of Citizens, a group of New Orleans residents who sought to repeal the act. They asked Plessy, who was technically black due to him being 1/8 black to a Louisiana law, to sit in the whites-only car of a Louisiana train. So the railroad cooperated because it was thought that the act imposed unnecessary costs via the purchase of additional railroad cars. When Plessy was told to vacate the whites-only car, he refused and was arrested. So the railroad cooperated because they thought that this act would have imposed unnecessary costs because they would have to buy extra railroad cars to support a black-only car, a whites-only car, and a colored-only car. So the police came to arrest Plessy. They told him to leave. When he didn't, he was arrested. And so at the trial, Plessy's lawyers argued that Separate Car Act violated the 13th and 14th Amendments. The judge found that Louisiana could enforce this law insofar as it affected railroads within its boundaries, and Plessy was then convicted. So the main question was, does the Separate Car Act violate the 14th Amendment? And for those who don't know what the 14th Amendment is, it's pretty much saying all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, or nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. So basically, does this Separate Car Act violate that amendment, which is saying that there can be no law that is going to abridge any of the immunities and rights of a citizen of the United States? And Plessy, being born in the United States, had certain privileges and rights that needed to have been afforded to him by the United States. So this is what was being challenged. In a 7-1 decision for Ferguson, this is what was decided. The majority opinion was given by Henry B. Brown. So the court held that the state law was actually constitutional. In the opinion, the majority upheld state-imposed racial segregation. Justice Brown conceded that the 14th Amendment intended to establish absolute equality for the races before the law, but held that separate treatment did not imply the inferiority of African Americans. The court noted that there was not a meaningful difference in quality between white and black railway cars. So in short, this segregation did not in itself constitute unlawful discrimination. So in dissent, John Marshall Harlan argued that the Constitution was colorblind and that the United States had no class system. Accordingly, all citizens should have equal access to civil rights. So that was the dissent opinion. The majority opinion was saying that, look, there can be separate areas. If you want to separate people, that's fine as long as they're equal. This, however, leads to a argument that's called the slippery slope argument, because who's going to determine what's equal, depending on the state, obviously. And for the most part, this is pretty much what you would consider a Jim Crow law, where it would segregate against people of a different race or people who were not of the white race. So pretty much this opinion, when it went down, Plessy v. Ferguson, it led to a bunch of slippery slopes where, in turn, people could claim that they're giving separate but equal, even though they were not equal at all. And that led to number 3, Brown versus Board of Education of Topeka. This is probably one of the most important, in my opinion, it probably is the most important Supreme Court case in the history of the United States. So the background of the case was the consolidation of cases that were rising in Kansas, South Carolina, Virginia, Delaware, and Washington, D.C. They were pretty much arguing against the decision of Plessy v. Ferguson, where they were saying that in each of these cases, in each of the states mentioned before, African American students had been denied admittance to certain public schools based on laws allowing public education to be segregated by race. They argued that such segregation violated the Equal Protection Clause of the 14th Amendment. the plaintiffs were denied relief in the lower courts based on the case I mentioned before, Plessy v. Ferguson, which held that racially segregated public facilities were legal so long as the facilities for blacks and whites were equal, and being known as a separate but equal doctrine. So the segregation of public education was what the question was: does the segregation of public education based solely on race violate the Equal Protection Clause of the 14th Amendment? So basically, what happened here? People from Kansas, South Carolina, Virginia, Delaware, Washington, D.C., they were arguing that African American students were being denied to certain public schools based on laws that allowed public education to be segregated by race. So pretty much some public schools were being segregated based on your race, and so certain African American students were denied from certain public schools. And one person, which was Oliver Brown, he sued the Board of Education of Topeka in Kansas to see if this segregation actually violates the Equal Protection Clause. And in the unanimous decision for Brown, a majority opinion by Earl Warren, said that separate but equal educational facilities for racial minorities is inherently unequal, violating the Equal Protection Clause of the 14th Amendment, thereby overruling a precedent before with Plessy versus Ferguson. This case was decided in 1954. Plessy v. Ferguson was decided in 1896. So 58 years of the separate but equal clause, and it was overturned just like that. Chief Justice Earl Warren delivered the opinion of the unanimous court. The Supreme Court held that the separate but equal facilities are inherently unequal and violate the protections of the Equal Protection Clause of the 14th Amendment. The court reasoned that the segregation of public education based on race instilled a sense of inferiority that had a hugely detrimental effect on the education and personal growth of African American children. And this is actually correct. You saw this in a lot of cases that were reporting on the history of segregation, and you see that a lot of these public facilities that were meant for segregation were actually not equal. They were in far worse conditions than those for white people in the United States. And so in this unanimous decision, separate but equal clause overturned. That is unconstitutional. So now pretty much saying every person has the right to be accepted in the public school, or in this case specifically, the African American students that were denied from certain public schools, that is unconstitutional. They can't be denied solely on race. They can be denied on academics. Obviously, that's a meritocracy, but solely based on race in this case, absolutely not unconstitutional. So again, my opinion, probably the most important case, because it's probably the case that one of the most important cases that led to civil rights acts and to the eventual majority elimination of racism in the United States. And the fourth, controversial, I must say, to speak softly, Roe versus Wade, Jane Roe versus Henry Wade. And this is pretty much all about abortion. Me personally, I am very, very pro-life. I definitely believe that life begins at conception. And so this case is really hard on me because it pretty much makes it legal to get an abortion. But let me give you the facts of the case. So in 1970, Jane Roe, which actually was a fictional name that was used in the case, the actual name of the person was Norma McCorvey. So Norma McCorvey used a fictional name to protect her identity, used Jane Roe. She filed a lawsuit against Henry Wade, the district attorney of the Dallas County, Texas, where she resided. She filed a lawsuit that challenges a Texas law making abortion illegal except by a doctor's order to save a woman's life. So back in the day, abortions in some states were completely illegal except for in cases where the mother would die and an abortion is needed to save the woman's life. In the lawsuit, Roe alleged that the state's laws were unconstitutionally vague and abridged her right of personal privacy, protected by the 1st, 4th, 5th, 9th, and 14th Amendments. So the big question of the court case: does the Constitution recognize a woman's right to terminate her pregnancy by abortion? And in an unfortunate ruling by the Supreme Court, 7-2 decision was for Jane Roe, with a majority opinion given by Harry A. Blackmun. This is what happens in the ruling of the case. Inherent in the Due Process Clause of the 14th Amendment is a fundamental right to privacy that protects a pregnant woman's choice whether to have an abortion. However, this right is balanced against the government's interest in protecting women's health and protecting the potentiality of human life. The Texas law challenged in this case violated this right. So it violates one right, but it protects the potentiality of human life, but apparently it doesn't protect the interest of protecting women's health. So first, the court considered whether the case was moot, concluding that it was not. When the subject of litigation is capable of repetition yet evading review, a case needed not be dismissed as moot. Pregnancy is a class's justification for a conclusion of non-mootness. So, for those who are wondering, moot, the definition of moot is subject to debate, dispute, or uncertainty. So pretty much right here, the case was not moot. So it's not subject for debating. Pretty much when you're pregnant, they concluded that it's a classic justification of non-mootness, which pretty much it's not up for debate, not subject for debate. The Due Process Clause of the 14th Amendment protects against state action, the right to privacy, and a woman's right to choose to have an abortion falls within that right to privacy. A state law that broadly prohibits abortion without respect to the stage of pregnancy or other interests violates that right. So right there, that's kind of important to note because it says without respect to the stage of pregnancy or other interests violates that right. So this decision, it pretty much says that you can't fully ban abortion, but you can with at a certain point. For example, we have the heartbeat bill here in Georgia now where you can't abort after a heartbeat. Although the state has a legitimate interest in protecting the health of a pregnant woman and the potentiality of human life, the relative weight of each of these interests varies over the course of the pregnancy, and the law must account for this variability. Obviously, they're saying if you're going to abort early, that the court's pretty much saying the interests vary over the course of the pregnancy. Obviously, when it's a late-term pregnancy, it's much more horrible to abort in any case, but it's much more horrible to do it later in the pregnancy when it's fully developed and where it can be viable outside of the womb. In the first trimester of pregnancy, the state may not regulate the abortion decision. Only the pregnant woman and her attending physician can make that decision. In the second trimester, the state may impose regulations on abortion that are reasonably related to maternal health. In the third trimester, once the fetus reaches the point of viability, a state may regulate abortions or prohibit them entirely, so long as the laws contain exceptions for cases when abortion is necessary to save the life or health of the mother. So that's also very important because obviously a lot of pro-life people, they are completely against abortion except in cases where it's needed to save the life of the mother, and I agree with that premise. The last paragraph that I just read, it's pretty much saying once you hit the first trimester, the state cannot regulate an abortion decision, stating that only pregnant women and her physician can make that decision. Second trimester, a state can impose regulations on abortion that are related to maternal health. And third trimester, as I stated before, a fetus reaches a point of viability, a state can regulate abortions or prohibit them entirely. Prohibit them in terms of a third trimester, so long as those laws contain exceptions for abortion, again, to save the life or health of the mother. That to me is the most controversial by far besides Plessy v. Ferguson. Roe v. Wade is probably the most controversial Supreme Court cases because it pretty much made it legal for people to get abortions. And you get a lot of women that are pro-choice saying, it's my body, it's my choice. But I have news for you. It's not your body. There's another complete body that's created when the sperm fertilizes the egg. A brand new DNA is formed, and that is a life. Because if you found the same embryo or same organism on Mars, you would consider that a life. So why can't we apply that same rule here on Earth? I can do an entire episode on abortion because that's one of the topics that I'm most strong about, I guess you could say, because I'm extremely pro-life due to my beliefs politically and due to my religious beliefs. But that's where there's a history of the Supreme Court, and it's 4 of the most important cases. And that's going to be it for today's episode. If you enjoyed the episode today, make sure to give it a like and follow on any platform that you listen to. And I will see you again tomorrow in the afternoon. My name is Sebastian Giraldo, and you're listening to The Giraldo Show.